want to start today with the clear statement that no member of Congress should be utilizing inside information for personal profit. Mr. Savickas and Mr. Copeland, do you both agree that we should, at a minimum, update the Stock Act? Yes?
Yes, so certainly to that effect.
Mr. Savickas?
Yes.
Okay. And so then I think one of the questions is, what can we do to accomplish the ultimate goal of making sure that members of Congress aren't profiting from inside information? And I sometimes go back and think about the situation that occurred here 5 years ago. And on February 13, 2020, as we're heading into the COVID pandemic, the chair of the Senate Intelligence Committee called his stockbroker and sold all but one equity in his entire portfolio for a tune of $1.6 million. If you're the chair of the Intelligence Committee, almost by definition, you have information that's not available to the public. And at an absolute minimum, that's an appearance of impropriety. The SEC and others looked into this, and their challenge, of course, is can you prove this beyond a reasonable doubt, which is the standard for prosecution under insider trading. And so then we have to look and explore what reforms need to be made to make sure that this type of action doesn't happen again. Mr. Copeland, in your testimony, you stated that no member of Congress has ever been prosecuted under the Stock Act. We just talked about the instance that took place in the Senate. Why do you think that's the case, that no prosecutions have come under the Stock Act?
Partly for the burden of proof you talked about. I mean, reasonable doubt is relatively high. You have to have a scienter requirement or a knowledge requirement. Also, the way the Stock Act structured is it's a self-policing. In other words, you have your own House and Senate committees in charge of this. Now, there may be good reasons for that. Conflict among the branches is something you have to worry about. You have to worry about, an executive branch run by one party going after the members or senators of another party and things like this.
We've seen that
so
plenty
I
of
think
times.
But that's my hypothesis. I wouldn't infer from the lack of prosecutions that nothing bad's happened, right? So.
But I would completely agree with you that from the lack of prosecutions, it's not because nothing bad has happened, it's because the standard for insider trading is incredibly high to prove. It happens on occasion. There are members that have been charged and convicted of insider trading. Under the Stock Act, we're looking for Congress to police itself without the traditional apparatus of a judicial process. I want to dive in a little bit into some of the proposals that came before us. The Restore Trust in Congress Act is one of the bills that have come before us. In that, it picks up things other than just stocks. It picks up commodities and other items. I talked to a couple friends of mine who own farms and said, if you were to become a member of Congress, how would this impact you? Could you operate your family farm with no trading of commodities whatsoever? If you say you raise soybeans, you grow corn, we want to have people that represent a wide array of backgrounds, whether that's a business background, a military service background, a farming background. Is that something, how should we think about that, Mr. Copeland?
Yeah, I think it's really important to think about the panoply of things that may be over-included and create some pretty obvious safe harbors so that we wouldn't exclude people that we'd want to be able to serve in this body. Agriculture is a good example of that. The commodities business is complex and needs to be thought about. There are other bills in front of the committee or in front of the House that talk about other situations where you may have illiquid assets that are hard to divest of quickly, things like venture capital, private equity. We don't want to create a prophylactic rule that would exclude people who are successful from this body. Yeah. I mean, from John Hancock to George Washington, at the very beginning of this country, we've had very wealthy people that have served in public service.
We are benefited from the array of backgrounds that members bring to this institution. Mr. Savickas, just taking that one example, do you think that would cause a challenge for somebody who has a family farm?
As far as I'm aware, the Restore Trust in Congress Act has limited family exceptions for occupational-related investments, I think, to address the problem that you addressed here. So I think...
So some nuance and some regulations to say, if you have nothing to do with farming, you shouldn't be trading in cattle futures. But maybe if you have a giant cattle ranch, it may make sense in some regard. As we think about profit, is pre-disclosure something you've thought about, Mr. Copeland? on a way to remove the financial incentive of an individual?
I think pre-disclosure is something that we ought to consider. I mean, again, there may be exceptions. If someone has a large stake in a large enterprise and they're going to necessarily have to disclose in many cases already, but pre-disclosure could actually create trading opportunities in the market and things like that if you have someone very wealthy. But for the vast majority
It
of
would
members,
have flushed out the
wouldn't be an
case in the
issue.
Senate, right? You would have had somebody, instead of calling their broker and nobody finding out for 45 days under the Stock Act, if you had to make a notification you're going to sell a share in a month from now, the entire American public would be privy to that action.
In the ordinary case, it would be.
Cognizant of the time, I'm gonna reclaim the time and yield back, and I'll recognize the ranking member for his 5 minutes.